Silence isn't calming this down, it's making it louder. Here's the contradiction. While Donald Trump goes quiet, posting family photos, floating headlines about Greenland, then Canada, the most explosive issue attached to his name is accelerating underneath him. And it matters to you because this isn't just about one scandal. It's about what happens when a government says it's too busy to prosecute active criminal cases because it's reviewing documents about a dead man. Fact. The Department of Justice has told federal judges it is not prepared to handle multiple major cases because lawyers are diverted to reviewing the Epstein files. That includes the Maduro prosecution and an upcoming sex trafficking trial involving Florida real estate brokers. That's not speculation. That's what DOJ lawyers said in court. Inference. Going silent doesn't look like damage control. It looks like a bet that attention will move on before accountability arrives. Now, here's where it tightens. Back in February, the Attorney General publicly announced that the first phase of Epstein files had already been released. The FBI said nearly 1,000 agents and lawyers were working on this review for months. Overtime billed, transparency promised. So if all of that already happened, why are judges now being told the system can't function? Notice what isn't being explained. Because once you see how this justification is being used in real courtrooms against real defendants in real sex trafficking cases, the story stops being about files and starts being about leverage. This doesn't land as a single delay or a paperwork excuse. It fits a pattern. The core event isn't just that the DOJ asked for more time. It's how they justified it and where that justification is now showing up. In New York's Southern District, one of the most powerful federal prosecutor offices in the country, judges are being told that nearly 2/3 of the office's lawyers are spending all or most of their day reviewing Epstein files. 200 lawyers, one review, and suddenly everything else slows. Fact. According to a DOJ letter cited by the New York Times, prosecutors said their work on cases like the Maduro prosecution was diverted because of Epstein document review. Judges set new hearing dates specifically to leave time for lawyers to work on those documents. Here's the reframing question that changes how this looks. If the Epstein review is consuming this many resources now, what exactly was happening during the months when the DOJ said the first phase was already done? Because that's where the timeline starts to clash. February, March, April, May, June. The DOJ said the files were already being reviewed. The FBI said nearly 1,000 agents were assigned. Tens of thousands of overtime hours were billed. Yet now, when unrelated trials are about to begin, prosecutors say they're not ready. Now watch how fast this escalates. Because once courts start accepting we're too busy with Epstein as a reason, the Epstein files stop being a transparency effort. They become a bottleneck. And the next detail shows how that bottleneck is already reshaping active criminal cases. Here's the first hard proof that this isn't abstract. On the record, in writing, the Department of Justice told a federal judge that nearly 2/3 of the 200 lawyers in the Southern District of New York were spending all or most of their workday reviewing Epstein-related documents, not assisting, not consulting, reviewing. That's one of the most powerful prosecutorial offices in the country, effectively admitting it can't multitask. Fact, in the Maduro case, prosecutors said their work had been diverted away from narco-terrorism charges because of the Epstein file review. The judge scheduled the next hearing for March 17th, specifically to give them time to keep reviewing those documents. That detail matters because it tells you the Epstein review isn't a side project. It's now being treated as operationally dominant, and once a judge accepts that explanation once, it becomes usable everywhere. But notice what's missing from that explanation. There's no accounting for February, or March, or April, or May. No explanation for what 1,000 FBI agents and lawyers were doing for months while billing massive overtime. No explanation for why Phase 1 was announced before this crunch supposedly began. And this is where the story flips, because the next case shows the cost of this bottleneck in real time, with real people and a deadline the DOJ can't quietly move. This pressure doesn't stay contained, it spills. And when it does, it shows up in the worst possible place, on the eve of a high-profile federal sex trafficking trial. Not a closed case, not a historical review, an active prosecution with defendants, evidence, and a trial date on the calendar. Fact, in that case involving two celebrity real estate brokers and their brothers, a defense attorney told the judge the government had not finished reviewing seized evidence that legally had to be turned over before trial. His words were blunt: "We have a trial starting next week, Your Honor." This wasn't a delay request in theory, it was a countdown. The judge's response is the moment that should stop you. Judge Valerie Caproni suggested that maybe a few prosecutors could be sprung from their Epstein review duties to meet their obligations in this sex trafficking case. Then she added the line that quietly detonates everything. That seemed reasonable, she said, given the fact that these people are on trial and Epstein is dead. That sentence does something powerful. It draws a line between what should be urgent and what shouldn't be, between living defendants and a deceased offender, and it exposes how inverted the priorities have become. Historically, document reviews don't halt prosecutions. They run in parallel. They're staffed. They're compartmentalized. They don't freeze an entire office. But here, the abnormal is being treated as normal, and judges are being asked to accommodate it. This is where normalization begins, where an excuse becomes precedent. And once that happens, the Epstein files stop being a transparency process. They start functioning like a shield. Because if this logic holds, any delay can be justified. Any case can wait. Any accountability can be postponed. And that raises the question no one in court has answered yet. What happens when this excuse gets used again? And it doesn't stop with one courtroom. It stacks fast, quietly, almost mechanically. While judges are being told prosecutors are overwhelmed, another fight is unfolding behind the scenes over who, if anyone, is allowed to oversee this process. Fact: lawmakers Thomas Massie and Ro Khanna asked the federal judge in the Ghislaine Maxwell case to appoint an independent monitor to oversee the release of the Epstein files, not to interfere, not to prosecute, just to ensure the process was independent. Their argument was simple: the Department of Justice could not be trusted to police itself. The DOJ's response came late on a Friday night, and it was aggressive. Fact. The DOJ argued that Massie and Khanna didn't even have standing to make the request. Then it went further, claiming the Epstein Transparency Act provides no private cause of action at all, meaning no court has the authority to enforce it. In plain terms, the DOJ told the judge that no one can compel transparency, even under a law explicitly labeled transparency. Now stack that with what you've already seen. Prosecutors say they're too busy reviewing Epstein files to handle active trials. Judges are being asked to accept that explanation. And at the same time, the DOJ is arguing that courts have no power to oversee how those Epstein files are handled in the first place. What happens if this continues? Because when a system claims it's overwhelmed, refuses outside oversight, and delays unrelated prosecutions, that's not just inefficiency, that's a pressure point. And the pressure doesn't stay inside Washington, it moves outward, straight to people who have nothing to do with Epstein at all. Here's where the story stops being about politics and starts hitting real life. Because when federal prosecutors say they don't have the resources to do their jobs, the impact doesn't land on abstract institutions. It lands on people waiting for justice. Defendants, victims, families, communities. Fact. The DOJ itself has acknowledged that more than 3,000 employees have left the department over the past year, a level of attrition far higher than previous administrations. That means fewer prosecutors, fewer support staff, fewer people to move cases forward. Now connect that to what you've already heard in court: active sex trafficking trials delayed, evidence reviews unfinished, judges forced to ask whether someone can be pulled off Epstein duty so living defendants can be prosecuted. This isn't ideological. It's operational, and here's where it reaches you. When high-profile cases stall, lower-profile cases don't get priority. When offices bottleneck, everything slows, investigations drag, charges wait, and the message that sends is subtle but powerful. Accountability is optional when the system is overloaded. If this feels familiar, say so in the comments. Because most people don't experience justice through headlines. They experience it through delays, through continuances, through being told not yet. And once not yet becomes standard, trust erodes quietly. This isn't outrage, it's gravity. And the next part explains how a system ends up here without anyone openly admitting that's what's happening. What allows this to happen isn't chaos, it's structure. Systems don't break loudly. They bend quietly around incentives. And once you see the mechanism, the confusion disappears. Fact. The DOJ has publicly framed the Epstein file review as an all-consuming obligation, while simultaneously arguing in court that no outside party and no judge has the authority to enforce how that process unfolds. Heavy workload on one side, zero enforceable oversight on the other. That combination matters, because when there's no deadline that can be imposed from the outside, delay becomes elastic. Review can stretch, priorities can be rearranged, and everything else has to adapt around it. Here's the unsettling insight. The Epstein files don't need to be released or buried to have power. They only need to be in review, permanently unfinished, always pending, forever important enough to justify postponement. Notice what this setup rewards. It rewards caution over resolution, process over outcome. It creates a state where nothing technically stops, but nothing meaningfully concludes either. And that's the sweet spot for avoiding final accountability without openly refusing it. This is why the story feels slippery, because no one is saying we won't prosecute. They're saying we can't yet. No one is saying we won't release. They're saying we're still reviewing, and systems built on not yet can last a very long time. But momentum doesn't freeze forever. Pressure keeps building. Judges keep noticing. Deadlines keep approaching. And the next phase of this story isn't about what already happened. It's about what comes next. From here, the trajectory splits, and neither path is stable. One path is normalization. Judges keep granting time. Prosecutors keep citing Epstein review obligations. Active cases inch forward, slower each time. The explanation becomes familiar enough that no one expects a resolution date anymore. In that version, nothing explodes. It just drifts. Accountability fades without a headline moment, replaced by procedural fog. The other path is collision, because courts don't operate on patience alone. They operate on calendars, trial dates, rights. Judges already on record are signaling limits. When one judge says it's reasonable to pull prosecutors off Epstein work because Epstein is dead, that's not frustration, that's a warning shot. Fact, judges have already questioned why entire teams remain locked into document review while live defendants wait for trial. They've already suggested reallocating resources. That means the justification is starting to wear thin, and once that happens, the next move won't come from press conferences. It'll come from orders. Deadlines that can't be explained away with another letter, decisions that force prioritization instead of delay. This is why silence isn't calming anything down. It's narrowing the window, because the longer everything is framed as under review, the more obvious it becomes when that review is being used as a holding pattern. Something has to give. Either the bottleneck breaks or the courts force it open. And the final part of this story isn't about Trump or Epstein or even the DOJ. It's about what happens when delay itself becomes the strategy. Here's the part that ties everything together. Delay isn't the absence of action. It's a form of action. When every answer is later, later becomes the outcome. The deeper insight is this. The Epstein files aren't just documents. They've become a variable that reshapes everything around them. Trials slow. Oversight is resisted. Resources are reallocated. And all of it happens without a single explicit refusal that could trigger immediate backlash. Fact, the DOJ has simultaneously told courts it's overwhelmed by Epstein review and told courts they lack authority to enforce transparency under the Epstein Transparency Act. That contradiction isn't accidental. It's functional. Reframe the entire story in one sentence. A system doesn't have to shut down accountability to weaken it. It only has to keep it perpetually unfinished. That's why the silence matters. Not because it hides facts, but because it bets on fatigue, on attention moving on the public getting used to still reviewing as a permanent state. But fatigue isn't the end of stories like this. Pressure is. And pressure doesn't come from headlines. It comes from deadlines, judges, and cases that can't be paused forever. This isn't the final chapter. It's the hinge, the moment where delay either collapses under scrutiny or hardens into precedent. If you want to stay ahead of what comes next, follow and subscribe. We'll track the next move as it happens, not after it's already normalized.